Hello friends, in the series on income tax cases, today we will discuss a case in which the issue before Delhi ITAT C bench was that if some additions are being done by the assessing officer regarding some share application received by the assessee, and the assessing officer has done inquiry under section 133 subsection 6 and has made the addition on the basis that the share subscribers are showing very low income in their income tax returns, and the CIT appeal asked the assessing officer to do some specific inquiry in the remand proceedings, and the assessing officer do not do that inquiry. So whether in that case the addition is justified on the basis that some share subscribers are showing very low income in their income tax return, or the directors of subscriber companies have not responded during the assessment proceedings under section 131. This issue has been taken up by Delhi ITAT C bench in the case of Assistant Commissioner of Income Tax versus A1 Arsh Exports Private Limited, and this case is reported in 134 ITR Tribunal at page number 754. The date of the judgment is 14th January 2026. The present case relates to the assessment year 14-15. In the present case, there was a survey on the assessee, and in that survey it was found that the assessee has received share application money of rupees 15 crore from 23 share subscribers, and some trial balance was found at the premises of the assessee, on the basis of which the notice to the assessee under section 148 was issued. During the assessment proceedings, the assessing officer made inquiries under section 133 subsection 6 from the 23 share subscribers, and all the 23 share subscribers responded to the notices and provided their bank statement, income tax return copy, confirmation, and all the necessary evidences. The assessing officer found that share subscribers are showing very low income, so he made a belief that this money is the assessee's own money and has been routed through those share subscribers, so he made the addition under section 68. During the assessment proceeding, the assessing officer has also issued summons which were not responded by the share subscribers. When the matter was before the CIT appeal, the CIT appeal sought a remand report from the assessing officer and asked specifically that whether the statement of any employees or directors of the share subscriber were recorded, and the assessing officer, when submitted his remand report to the CIT appeal, the assessing officer just copy and pasted the assessment order in that remand proceedings and did not make any further inquiries or did not record any statements of the subscribers of the share application money in the company. So the CIT appeal deleted the addition on the basis of the remand report and on the basis of the evidences which were filed on record. The revenue filed the appeal before the tribunal, and when the tribunal heard the matter, the tribunal was of the view that in the present case the assessee has submitted are the primary evidences, so the onus was on the AO to conduct the further inquiry, which was not done by the assessing officer. The tribunal said that this is a case where no case for any intervention is required by the tribunal. The tribunal said that in the present case the assessing officer has reiterated the arguments taken in the assessment order. The tribunal said that no inquiries were done by the assessing officer in the remand proceedings, and when the CIT appeal has asked specifically in the remand proceedings that whether any statements were recorded, so for that the assessing officer has just mentioned that no statements were recorded. So the tribunal was of the very considered view that the CIT appeal has comprehensively analyzed the entire controversy and has rightly deleted the addition. Friends, this case is very important because it is generally seen that the assessment orders are being passed just by denying or without refuting the evidences submitted by the assessee and without any inquiry. So all those assessments are not as per the principle of natural justice. Without inquiry, the additions cannot be made. At the end of this video, once again, I am repeating the name of the case. The name of the case is Assistant Commissioner of Income Tax versus A1 Arsh Exports Private Limited, and this case is reported in 134 ITR Tribunal at page number 754, and the matter has been decided by Delhi ITAT C bench on 14th January 2026. Thank you, friends.